Hey, welcome everybody. We are live with the Rebel Alliance podcast. I'm your host, Aaron, and thank you for coming by and listening or watching wherever you're consuming this from another episode. So today is March 7th. It is about 4:38 East Coast time. I did not realize that when I set this up in Yardstream this morning when I got home from work, I was a little tired and I put 1:30. It should have been 4:30 because I had some phone calls earlier on that I had to get up for and whatnot. So I apologize for that if any of you had tried to tune in at the 1:30 time frame. So today we are going to be talking about defending your private membership association, as this has come up a lot and there is a lot of as always, bad information out there. But before we get into it, I want to just take care of some of the housekeeping and get that stuff out of the way. So as always, if you're looking for more content and you are looking for DIY templates, for those of you who haven't heard, the websites in both locations, the East Coast PMA and the ladies over at the PMA Manifesto, are both up. So you can head over to East Coast PMA to get more information, past episodes, blog posts, all that type of stuff, more information, downloadable content, documents that I reference, all that stuff is over at East Coast PMA, and it is updated on a regular basis. And for those of you who are new, if you see me looking over to the screen, it's just because I got multiple screens here and I'm trying to be a one-man show. So that also being said, you can always go over to the pmamanifesto.com. You can get DIY templates over there. You can interact with the ladies, the two Angelas and Erica, should you want to talk to them about any specific questions. They are in New Jersey, Maryland, and on the West Coast in California. So maybe you don't want to talk to me. Maybe you don't like my personality or the way that I present things. So give them a shout. You can schedule a time with them over there. And they also have different content that you most likely in most cases, it doesn't overlap with the East Coast PMA. So you'll have some other information over there. And then tonight, I believe it is from 8 to 9, 7 to 9. Now I got to look. Anyways, we have our monthly call where we do a video call with anybody who wants to jump on. They can ask questions. We can answer them for you. If it's in our wheelhouse and we have the answer, we will. And we do that once a month, and you can get on there. If you're part of the Facebook group, the PMA Manifesto or East Coast PMA, you will see the link in a post. I will be doing the East Coast PMA one shortly after this podcast, right before I get dinner together for all the little savages in the house. So that being said, the last thing that I want to bring your attention to, which hopefully next week or the week after, I will have one of the individuals from Start 9 on here to kind of elaborate how the system works, because I am pretty novice to it. Like, I know how to install different applications on it because it's like working a phone. But if you want to take back your computer sovereignty, you want to have that end-to-end encrypted text messaging. You want to have text messages that burn upon reading. You want to run your own form of a PayPal using Bitcoin or BTC Pay. Maybe you want to run your own Lightning node. Maybe you just want to run your own Chat GPT, that the data is not being shared anywhere and you're running your own language models and stuff like that. That's what the Start 9 Embassy servers are for. And if you use the code Rebel Alliance at checkout, you get 9% off of that. And that also helps this podcast, these episodes, broadcasts, whatever you'd like to call it. And some of you have used that already, so I do appreciate that. So that being said, I don't expect there to be a lot of comments today. Most of the comments come in after the fact, but because the times have been so screwy lately, hopefully this is the last week and things will be more on a consistent schedule, because I have some things that are now coming off my plate that will be finished projects. So that will be nice. But you can leave your comments on Facebook, YouTube, Telegram, or Rumble, even though I don't check Rumble as much because I don't get notifications. So it's when I go in there to do stuff, I usually see them. But most of the comments come in through Facebook or YouTube. So that being said, I guess before we get into this, none of this constitutes as tax or legal advice, as always. This is my opinion on how I would handle things if I was in this situation. There are a lot of different outlets that you can go to look up information on associations, or PMAs as they're commonly called online, even though they really are unincorporated associations. By legal definition, that's what they are. So be very careful. There are many people on YouTube that have way more followers than I do, and it's because they're pushing things that are acceptance for value, your trust account, all these different patriot mythology things or these topics that have been pushed for decades. And I've yet to have anybody show me proof where any of this stuff actually works. And all you do is see it fail in court, and it gets chalked up to frivolous arguments or incoherent legal nonsense that's put together on paper because it's what somebody had wrote. And I'm going to go into this in more depth in another video, but there are a lot of individuals that are charging a lot of money for information that is bogus, and it's not going to help you any. So be very careful who you spend your hard-earned money with. And anyways, that's just my take on that. There's been more of this being brought to my attention and people talking about it, and I'm like, well, yeah, well, he gets into patriot mythology and all this other stuff, and he also sells PMAs, and he calls them PMA, private membership associations, 508c1a, something else. And I don't have his website up anymore because I was lurking a little bit on there. But that being said, just because I want to see what they're talking about before I comment on it. So that being said, that's a good beer. Yep. It's beer time. So that being said, let's get into episode 70, defending your private membership association. And I will probably put a lot of this stuff on East Coast PMA also. And it's just because I get a lot of questions about this. Now, one really good resource for what we're going over today is if you go over to Dr. Graves' course, How to Win in Court Without a Lawyer. I believe he's in the process, according to the Telegram group that I'm in. He's switching up his server. He's been on his server for the last 20 years. They've been having some issues. Very similar to, I think, what we went through. I think ours, was that rad driver. So I don't know how old the server was that we were on. I was with them for a few years. They were really great. Unfortunately, I had to switch because they were very cost effective. But again, he's running into the same problem. So if you get to the website, if you use the link on East Coast PMA, there's a little yellow right-hand side image you can click on. It will bring you to Dr. Graves' course. It's, I don't know, $300, I think, for the year. And then you get a reduced rate if you renew it earlier. But there's a bunch of video on there. There's a bunch of audio. There's tests. There's a lot of explanations. And it really goes into a lot of different things, everything from civil to family and everything in between. So the basic concept for today is if you have an association and you get a knock on your door, you have somebody from some official office, whether it's the town government, local, your state government, maybe the federal government, depending on what you're doing. And you need to be able to interact with these people, and you need to understand how the processes work depending on what they're doing. Now, I'm not going to dive into everything. This is kind of going to be like everything else, just kind of an overview. If you have certain questions, feel free to reach out to me, schedule a time. I do offer consulting stuff now. Again, I don't offer any legal advice. It's just what I would do. And if it's anything that I don't think I have the answer for, or nothing I've dealt with in the past, then I would direct you to proper legal counsel if that's something you wanted to do. That being said, let's just kind of get into what happens overall. So there's most likely in most situations, you're going to get a knock on your door, especially we see this with education associations or anybody providing education to their to children that are not their own. So any type of drop off, anything like that, where they look at as a unlicensed child care facility. Now, that being said, most of the time it's just a knock and announce. They want to know, they want to let you know who they are. They've gotten some complaint from somebody supposedly, and they want to know what's going on. Now, in most cases, you don't have to answer any of these questions. You can tell them to come back when it's convenient to you. You're not answering anything they want to send to you, they can send in writing if you want to go that route. Or you can go the route where, yeah, sure, we do provide education to our members' children. We are not open to public, you know, uh, public accommodation. That's the word I'm looking for, and kind of go for there. If you have any questions or anything you'd like to leave me in writing, that'd be great. I'd be more than happy to answer for you. But right now we have things going on, and unless they have a warrant, tell them to piss off, pretty much, right? So, but sometimes just being cordial with them makes things go a little bit easier. Now, if it gets pushed, now it could come in a form of a regular complaint, which is, the plaintiff saying something has happened, whether it's a breach of contract or what have you. But in essence, there's going to be a complaint. And if you get Dr. Graves' course, it goes into this a lot more in detail than what I'm going to have time for here today. So you'll get a complaint. It could be a cease and desist. It could be just a letter from the local authorities, whoever it might be, whether it's the education department, licensing, housing authority, I don't know, whatever it could be, right? So you just want to, one, answer that. What you don't want to do is you don't want to stick your head in the sand. You don't want to say, I'm in the private, you have no jurisdiction here, because that is not going to work for you. I'm telling you that right now. I've seen it time and time again where you go to any of these other people that talk about associations that tell you have a private ministerial, faith-based, nonprofit 508c1a belief in nature, or whatever it is you want to add to it, like this long thing. Like, you can't be an association and be a ministry. You have to be one or the other. Sometimes you can tie them in, but very rare occasions, and it all depends on how your documents are written. So what they get is they get a lot of dumb information, a lot of bad information, because these people don't know what they're talking about. They haven't dealt with anything like this, and they're going off of what somebody else has said that has never dealt with this either. And in most cases, it's just a, hey, let's play ostrich or let's play possum, stick our head in the sand, play dead, don't answer anything. And then what you know is you go from a letter to a cease and desist to a judgment against you. And before you know it, it happens. And you're now playing catch up because you didn't answer anything, or you didn't understand the process. So that's kind of what I'm trying to go over here today. So what we're going to talk about is we're going to talk about complaints. We're going to talk about flurry of motions. We're going to talk about answers, discovery, and then in most cases, trial. So um, basically, a complaint is this: the plaintiff states allegations or demands a judgment for something. So it could be something, and I'm going to try to keep this maybe not necessarily within the association realm. So let's say a breach of contract or a violation of some state statute, and you need to go to look at that state statute to kind of see what they're going to be using as their allegations, and then build your defense from that, right? So you're going to have your complaint. Now, once you receive your complaint, depending on the jurisdiction that you're in, your state, it would probably be good to look to see if you have a practice book for your state. So, like here in Connecticut, I can download the 2024 practice book, and it comes in a PDF. It's probably about 500 pages, and it lists everything from A to Z. So I know that if I'm going to file a motion, let's say motion to dismiss, if there's something I need to file a motion before that, it tells me, and it gives you the order, because in each area it's going to be a little bit different in what you do. So you want to make sure that you have let me just see here. I wanted to pull something else up while I'm talking, because this might come into play while we're talking here. So I'll put it up over on this screen. So you want to know in your area what the time restraints are, because what you don't want to have happen is you don't want to miss a time restraint. So if you have 30 days to answer a complaint, you want to make sure that you answer that complaint within that 30 days. And in most cases, what you would do is you would file a motion to dismiss. So the motion would ask the court to dismiss some or all the claims in the case. It is often filed early in the litigation process, arguing that the plaintiff's complaint fails to state a valid legal claim or anything like that. Maybe it's a lack of jurisdiction, what have you. So again, you want to look into these things more in depth. And if you really want to know the nuts and bolts of everything, or the crust of the biscuit, however you want to put it, get over and take Dr. Graves' course. It's definitely worth it. And again, you can find the link on East Coast PMA. So you might file a motion to dismiss, right? And then that's going to be like your common motion right off the bat, is a motion to dismiss. And then there's going to be some other ones, and we're going to get into all of this as we go through it. So I kind of have like my top 10 of what you would normally, like the most common, I will call them the most common motions. So after that, there's a motion for summary judgment, and these are in no particular order. It doesn't mean you're going to use all these. It doesn't mean you're going to use some of them. It's just some of the common motions you'll come across when you get a complaint. So remember, when you get a complaint, or even we'll just call it a complaint for general argument here. When you receive something formally from one of these agencies that says you're operating an unlicensed daycare facility, you're selling eggs to your neighbor, and you need to stop because it's not gone through the USDA. There's all these, whatever the complaint is, you need to read the complaint. You need to make sure you understand the complaint. And then you need to, before you answer the complaint, file your motions, right? And Dr. Graves calls that your flurry of motions. So some of the other motions that you might come across is motion for summary judgment. This motion asks the court to decide the case without a trial because there is no genuine dispute of material facts, and one party is entitled to judgment as a matter of law, right? And again, these are in no particular order. It doesn't mean you're going to use all these. It might mean you might use some of them. So I put this one as motion to suppress evidence. That might not be right. It might be motion and Lyman, which is the next one I have. So you can have, we'll just call motion and Lyman. You can have one that asks the court to keep evidence in, and then you can have one to exclude evidence. Because it might be irrelevant to the case. The information might be hearsay, and we see this sometimes with some of the cases where if you go to case law or case mine or Google Scholar or any of these other places where you can look up case law, like if you download Westlaw's app on your phone, you can search court cases for free. It's really hard to like copy and paste stuff, but it gives you a chance to read stuff without paying the overly ridiculous prices for Westlaw. But you can see that in some of these PMA cases, they'll file these motion and Lyman to exclude the whole argument that you are a private association or an unincorporated association. In most cases, they say private membership association that is secured, or that is allowed, I guess is maybe a better word for it, by the First and 14th Amendment. And they say because it's going to confuse the court, or if you go to a jury trial, it's going to confuse the average person. So you need to be ready for some of these things when they come up and how to combat them. Another one's going to be motion for continuance. This motion requests the court to postpone a scheduled hearing or trial to a later date. So maybe you got a complaint, you filed a motion to dismiss for whatever reason, it didn't work, and then you have a trial date coming up, but because you're doing this pro se and you didn't hire anybody, and again, you're going to hear other attorneys, other legal professionals, and I agree. In some cases, you should not represent yourself, right? Only a fool represents themselves. But in some cases, there are small things that I think that you can represent yourself for, and I think I look at it kind of as like you're not going to maybe I shouldn't say it this way, but if you have a house and you rent it out, nobody's going to take care of your house as well as you. And sometimes I feel that nobody's going to represent yourself as well as you. As long as you know how to do it properly, then if you hire somebody. Now, there are good attorneys out there. There are good constitutional attorneys. I mean, look at Robert Barnes and everything he's doing for Amos Miller. But again, some of us don't have really deep pockets. And if it's small things, then maybe it's better to represent ourselves and go through it. And the court usually is a little bit more lenient with somebody that is pro se, that represents themselves. You just got to make sure you know the process, and trying to learn the process while you're going through it is really going to make it more difficult for you. So I just wanted to say that real quick. So you want to file this motion for continuance because, okay, you've had the complaint, you've tried a motion to dismiss for whatever reason, it didn't work, and now you need a little bit more time before you go to maybe a hearing for a temporary injunction or a cease and desist or something like that, or whatever the complaint is. And so you file a motion of continuance for maybe 60 days because you have to get all your ducks in a row. And now because you didn't take Dr. Graves' course or listen to what I'm saying here or do more further research, you went down some patriot mythology rabbit hole where it's not going to work and you're filing affidavits that are worthless. Then maybe you're playing catch up. So you need to get your ducks in a row. So this is where the motion for continuance would come into play. And I'm going to turn the comments on because we got a few people watching here and there. So just in case they have any questions, feel free to drop them in and I will answer them at the end. So after you have your motion of continuance, another one that you're going to see very frequently, especially if you're going through the process, is going to be a motion for discovery. And this motion seeks to compel the opposing party to provide relevant information or evidence that's within the possession or within their possession or control. Discovery motions are crucial for obtaining information necessary for trial preparedness. So maybe somebody came through and they took photos of your association, your PEA, or whatever it is you have going on, and they weren't supposed to. This happened in one case that I was trying to help somebody out with. And, again, it didn't really work in our favor, but I was like, that is material evidence. They had a search warrant to come in and look, but they didn't have a search warrant to come in and photograph and take photos of just whatever they want. Again, a search warrant has to be specific in the areas that they are going to search and what they are searching for. And so we tried to get all that stuff thrown out. And again, she was doing it on her own, so I can't be there. So, sometimes, things get misconstrued. But anyways, we try to do our best. And, again, you're fighting the state in most cases, so you really need to be prepared. So you want to know about discovery, and there's some different options for discovery. You can just do a regular discovery, and then there's a one to compel evidence and stuff like that. But again, your practice book in your state, if you have one, will tell you what how that has to flow. So maybe you have to do a certain discovery before the other one. And so, like, I just recently helped somebody with a debt collector. And so this debt collector wanted to, we would decide, okay, they just thought this person wanted a discount on what they owed. It really wasn't the case. We wanted certain documents. We tried to get the master purchase and sales agreement. They said, absolutely not. We're not going to provide that because it's proprietary information. I said, well, that's not how contract law works and evidence and the best evidence rule. So you need to provide it. So we ended up going to trial. Then we pushed it to arbitration. And then once we got to arbitration, they wanted to withdraw everything. And so they won, or my friend won. So again, you need to know how everything works. So, discovery will really help you in gathering that information to help build your defense, especially if they got something wrong or if you need to get something removed because it's hearsay or what have you. So the next one I have on my list is a motion to change venue. So this motion request can be the case request that the case be transferred to a different court or jurisdiction, often due to concerns about bias, convenience, or the inability to receive a fair trial in a crucial location. And where you see a lot of this is if, let's say, I think Connecticut's small claims is $5,000, right? Let's say you're suing somebody for a breach of contract for 6,500, and you filing small claims. That defendant is going to say, no, this needs to go to civil court because it's over the allotted amount for small claims. So you just want to make sure that if you are the one who's filing a complaint against somebody, that you're filing it in the right jurisdiction, so to speak. Now, this one we've been seeing a lot of lately, and this is a motion for a preliminary injunction. I think this is what just went through with Amos in Pennsylvania. And on that note, at least the Supreme Court got it right with Trump and was a 9-0 decision. So that was nice to see that, but we'll talk about that later. So I don't think the court systems are completely corrupt yet. Anyways, so motion for preliminary injunction. This motion asks the court to issue a temporary order requiring a party to refrain from certain actions until the case is resolved. Preliminary injunctions are often sought in cases involving urgent matters or irreparable harm. And this is where you're going to see a lot in not only a cease and desist if you have a PEA or private education association, or even a ministry, if you're providing education to your members' children, anything like that. They're going to say it's in the best interest of the children. There could be harm to the children. There's not enough staff there. They're not CPR certified, which you probably should be. Or they're going to say, we don't have you on record of who you are. You're operating illegally. So there could be irreparable harm to the children. So they seek a motion for preliminary injunction. And then you have to go to the court and fix that. All right. I will get to those in a second. And yeah, that's a good point. So I'll bring these up in a second. Just stay tuned to the end and I'll bring these comments up. So these are some of the things that you're going to come across, especially if you have a private education association. We'll just call it for that, for lack of a better description, because the state, in most cases, does not want kids pulled out of the indoctrination camps because they're not going to get money to have those kids there. And they don't have a hand in the cookie jar as far as what you're doing. And I think that we can all agree that the government has gotten too fat and overreaching. I mean, I can't even go out and hunt for myself without going to a safety course, even though I'm an NRA certified instructor, or I have to ask permission to go fishing. Like, I think it's ridiculous. And there's a lot of other things that I think are absolutely insane. So the next one that I've not come across, but it is common in more of criminal stuff, is the motion for protective order. This motion requests that the court issue an order to protect certain information or material. I'm sorry. I'm thinking this is a protective order to the police. We're not there. This is for the court. Good thing I wrote down notes. Protect certain information and material from disclosure during discovery process to prevent harm or prejudice to a party. And then number 10 is going to be motion for a judgment as a matter of law. Direct verdict is sometimes it's also known as. This motion is made during a trial and asks the court to enter a verdict in favor of one party because the evidence presented is legally insufficient to support the opposing party's claim or defense. So those are kind of like my top 10 motions. There's a lot more. You can do a search through whatever search engine you want. If you use a Start9 system, you can run your own search engine, which is even nicer, and it doesn't get filtered. And you can find a whole bunch of different motions that can be utilized. So once we go through our motions, and like I said, the most one you're going to use right off the bat is motion to dismiss. is you're going to start going into your answers in affirmative defenses. And affirmative defenses are basically additions to your answers, as Dr. Grave puts it, that has bite, and it allows you uh, to allege certain things or try to prove certain things. And again, I think it's on East Coast PMA. I was over like 100 affirmative defenses, or maybe it was 101 objections. I can't remember, but either way, there are a list of affirmative defenses that you can use. So when you, let's say you've gone through your motions, and you've done all your flurry of motions, as Dr. Graves puts it, and you can't, the case is still moving forward. You want to then have to answer that complaint. So when you answer the complaint, it's going to be admit, or how do I put it? Yes, no, or without significant information. So it's admit, deny, or without significant information. And you do not want to read into the questions. So, oh, I should have brought up some examples. Let me see if I can think of one off the top of my head. So something is along the lines as, let me think here. If Are you operating a unlicensed childcare facility, or you're operating an unlicensed childcare facility? I probably should have gotten some examples. I would say without significant information. I don't know what your definition is of an unlicensed childcare facility, right? Or if it's something with debt, do you owe debt to such and such collection agency? Well, maybe I owe debt to Citibank or Capital One, but that's not who's suing me. So I don't know if I owe you anything. Again, you haven't shown me the master purchase and sales agreement. So it's without significant or without sufficient information. So that's how you kind of want to read into these questions. Don't give them more than what they're asking for, right? If they say, do you run a private education association? Yes. Very simple. Yeah, I do. I have a membership that is private that provides education to its members. So yes, so you want to answer it in that way. Yes, affirmative, denied, or without significant or without sufficient information, right? So you need to answer the response to each allegation of the plaintiff's complaint, along with the defendant stating any allegations in defense. And this is where your affirmative defenses come in. And I thought I put something in here for affirmative defenses. There is a list, and I don't have it in front of me. And I don't think I'm going to have time to pull it up really quick. Let me see here if I can pull up what I'm looking for. So let's see. Let's see here. So there are many different affirmative defenses, and I wish I had them in front of me. But of some of the affirmative defenses you could use is like, failure for consideration. If it's like a contract agreement type thing, maybe there's an estoppel, maybe there's a lack of subject matters jurisdiction. Let me see here if there's anything else I can pull up here really quick. Coercion, comparative negligence, consent. Yeah, what I'll do is I'll put a list up on East Coast PMA, because there's stuff like, failure to join indispensable party, failure to, have unclean hands when you're coming to this, because maybe there's been some shenanigans within the complaint. Maybe there's a failure to state cause of action. So those are just some of the things. And I'll get a list together for all those that are listening or watch this in the replay, so you can get that list on East Coast PMA. So once you go through your answer and you include your affirmative defenses, you're going to go into, as it progresses, your discovery tools. And this is what comes into play for both sides. And you have 5 discovery tools. And those are request for admission. So, I'm trying to think here. Do we use a request for admission in the credit card one? We might have. I don't know if I have it. I don't know if I can find it fast enough. But basically, let's just say, hey, did you, you could, file a motion for request for admission and say, uh, ABC, did you purchase said debt uh, for less than face value, and they have to answer yes or no, or however you want to word the question. But you want to make sure they're very specific, and you're asking questions, not writing a story, right? And we see this in some cases where people start writing stories and not really just 1 to 2 lines direct questioning, kind of like if you were in a courtroom, right? And maybe it's a cross examination. You can do a little uh, uh all right, you got a lot of questions here. I will get to all those. And so that being said, so you have your discovery tool. So maybe it's a request for admission. Maybe it's request for production. Maybe you're going through your your discovery tools and you're saying, "Hey, I need you to compel this evidence." And then maybe they're talking about in the debt collection one, they were talking about a master purchase sales agreement was referenced many times, and even in some affidavits, which we all know are just stamped and pushed through. So we requested for production. Okay, produce this document that you're talking about. You can't talk about it without producing it. And this is where it comes into contract stuff, where, for example, I've heard it explained before is if I have a check and I go down to the bank and I say, I've got this check for $10,000. I left it at home. This is what the check looks like. This is who gave it to me. Here's a letter from the person saying they gave me this check. And, these are all here's the last four numbers of this check. And here's the amount, like they said here in this affidavit. I just need this check deposited into my account, but I'm not going to provide you the physical check, right? That's not going to work at a bank, and it's not going to work in court either. They have to provide you under the best evidence rule. If they talk about a certain document, they need to provide it. And sometimes they don't want to. So maybe you do a request for production. Then you can get into your interrogatories, your depositions, and your subpoenas. I've never used any one of those, so I'm not going to go into great depths on those. I think we all kind of know what a subpoena is. You're being subpoenaed to come into court to give testimony. A deposition is where you sit at a table, it's recorded. Usually both sides are there and questions are asked and answered. Very similar to interrogatories, but that's written that way. Now, one thing that, again, if you want to dive into this more, we're at 31 minutes here. If you really want more information on this and a really good course that is, I'm not answering everybody's question probably here in this, and they're probably going to have even more questions here on out. But these are kind of the things I'm going to try to start bringing to the channel more is, we need to understand how to defend ourselves when it comes to these associations or just life in general. But trust me, Dr. Graves' course for under $300 is going to be the best bang for your buck. You can find the links in the description for this video or any of the videos here on YouTube, Rumble, or I think that's it, Rumble and YouTube, maybe Facebook. I think the description's there too. But also, if you go over to East Coast PMA, you can see the link on the right-hand side. You can go pick up his course. Again, it is an affiliate link for me, so I think I get like $10 off it, which I appreciate because that just goes into help paying for the resources here, like Yardstream and stuff like that. But you're going to get a really good education on how the legal system works, and it's not like anybody can read it. If you have at least a 7th grade education, you'll be able to get through this and understand it. And then there's tests to test your knowledge and stuff like that. So one of the things that I want to bring to make sure that everybody understands before we close here and we go through some of these questions here is or statements is that when you are doing this stuff pro se and you're creating any documents that you are submitting to the court, you need to submit it to all parties. So not only like here, I can do e-filing in Connecticut. I don't know how it is in your area, but if I e-file something, I have to make sure I send it to the opposing party. So whether I'm the plaintiff, the defendant, it has to go to the other side. If it's attorney representing the other side, it has to go to that attorney. And then if the attorney is representing somebody else, let's say it's a family matter, you're representing yourself, your ex has an attorney, and your ex is also on maybe the separation agreement, whatever it is. You want to make sure she gets a copy or he gets a copy, the attorneys get a copy. You can send it regular mail. I prefer to send it certified mail. Then there's a tracking number. It shows that it was delivered. There's no way to say that they didn't receive it, even if it was somebody at the attorney's front desk. They can say, hey, here it is. Somebody signed for it. I don't know what to tell you. You were provided it. And then in most cases, they can say, hey, we'll also take electronic formats, but you want to have a certification of service saying that you sent it to such and such date. So usually what it says is like under penalty and perjury, I certify that a copy of the foregoing was provided by regular or certified mail, whatever you choose, and mail to, and then it's going to be their name, their address. And then underneath that is where you would have the section for the notary of republic. So you can, go to the notary at the bank or wherever, have it notarized, because you're not a licensed attorney. So any of us like myself that does a pro se, you have to have it certified through the notary. So and most of the time your banks don't charge either, so that's a great resource. Or like for us, we have a notary within our group and our association, so she does stuff for me most of the time, I think, but others also. And that goes for any other documents you might have to have notarized. Just make sure it's done, and then you can then mail that stuff off or upload it and what have you. So these are kind of my thoughts on, when it comes to defending the association. So again, you're going to have your complaint, you're going to have your flurry of motions, as Dr. Grave puts it. You're going to have your answer and affirmative defenses, and then eventually you're going to go to trial. And within that, you're going to have your between the complaint, the flurry of motions, and answers is when you can start using your discovery tools, and that's request for admission, request for production, interrogatories, depositions, and subpoenas. Now, here's something I wasn't going to touch on, but I think it's good information to have. And this is the federal criminal code that I think is important when dealing with people that are clothed in office. And this comes in, and I will put this on East Coast PMA, and I'll upload it to the Facebook and Telegram group. I'm not sure it's up there yet, uh, but there's a couple of different codes that I think are important for us to know if we want to file a criminal complaint against any of these individuals for how they're acting in their official and personal uh, position. So one is 18 USC section 241, conspiracy against rights. The other one is 18 USC section 242, deprivation of rights under the color of law. And then let's see, where is here's one that's really good if you have to deal with a debt collector and they're threatening you with anything, is 18 USC section 876, mailing of threatening communications. And let's see, what else do we have here? This one also is good, 18 USC section 1341, frauds and swindles. And then let's see, and that's wired radio. Let's see. I think that is it. But what you can do, there's also a 1940, section 1948. I don't know why I don't have it on here. Do I? 1951, 623, RICO. Alyssa's calling me. I'll call her back. Let's see here. No, I don't think I have it in here, but I'll find it. But anyways, what's really good is the deprivation of rights under the color of law and the conspiracy against rights. Those are definitely some you can use when dealing with individuals that are clothed in office, especially if they are violating your rights. So I'm going to go through this because I got to bring one of the kids to dance class now, and the time is just flying by. Yes, there is a meeting tonight. If you are on the Telegram group, I will post it there, and in the Facebook group for East Coast PMA. Salam, that is correct. It is tonight, so I'm hoping you'll be on there. It's good to see your face. So I think I need to have you on here so we can start talking about some more law stuff, because you have your group out in California, and so these are some of the comments here. You'll also be able to see them in. Yeah, it is. It always starts with a motion of preliminary injunction. 1 second, Andy. I'll be ready to go to dance in a minute. So this is why I try to do this stuff during the day when kids are at school, not in the house. 0 for 2. We're trying to fed off. Yeah. All right. Let's see here. Yeah, that's true too. Yeah, yeah. Yeah, I think we need to set up a time to have you on here, because I think, you're a wealth of as everybody puts it, the common law, which I think that just gets tossed around too much. But yeah, yes, this is great. Yeah, the rules of court and civil procedures can be learned, but it takes time, and you're going to need to go up against municipality codes, enforcement departments. You must master the rules and procedures. Yes, I agree 100%, because what happens is, and I'll leave it on this note here, is that most people go to these David Straits, David Jose's, the win for the bonds, the what was the one somebody just sent me? It must have been around for a while. The do I have it up still? Please tell me yes. Please tell me yes. No, I don't. It was something about affidavits, and they were charging people like ridiculous amounts for these affidavit stuff, or the affidavit wool for the wool. Just nonsense, right? And I probably should touch on this, but an affidavit is nothing more than a sworn testimony outside of court, and it means absolutely jack diddly unless you have a legal case going on. And there were people selling these affidavits for like $200 to $400 and then some, saying that if you have this affidavit and you show it to somebody at a local grocery store during the COVID slash pandemic, that you don't have to wear a mask. And that's just not how those work. But anyways, everybody, a lot of people prey on people's fear, and I think that's where we make bad decisions. So that's why I try to bring you stuff that I would do and how I would do it. It may not be the right way, but it's how I think it should be done, and it's how I've had experience doing certain things. So if you want to go down some of those rabbit holes, go for it. I've gone down most of them myself over the last probably 15 years. And again, it's just I always end up coming back to what actually works, because I only have so much time on this planet. We're all got that disease called death, and I don't want to waste my time on things that don't work, or fighting stuff like, hey, I want to drive without a driver's license. I don't. That's not anything I'm looking to waste my time on. But there's bigger things to worry about, in my opinion. So that being said, thank you all for jumping on. I hopefully see you some tonight on the meeting group. Let's see. What we got here? I have actual experience to share defending several PMAs from court actions. Yes, we will. Uh, we are definitely going to do this. We're going to get you on here, and tonight I will shoot me an email. I know you have my email. Shoot me an email, and let's set something up for next week and get you on here. And I definitely, think you have a lot of wisdom to bring, and maybe we can even get the East Coast versus West Coast thing going. No, I'm just kidding. But thanks for listening, everybody. Until tomorrow, have a good evening. I've got to get kids to dance class before I get yelled at. So I will talk to you tomorrow. Peace.